Okay, let's get started. Good morning. My name is Richard Ponte, and I'm the Director of Events and Programs for the Maine State Chamber of Commerce. On behalf of the entire team here, it is my pleasure to welcome you to this year's HR Update, Vice in the Workplace, Drugs, Gambling, and Sex, What Employers Need to Know, the latest in our webinar series. Thank you so much for joining us. Before we get going, there are just a few things we'd like to share with you about today's session. All participants are in listen-only mode. Please submit questions using the Q&A function. Time permitting, we will answer them by the end of the session. We will also use the Q&A feature to share useful links and other materials. We have enabled closed captioning in English. You can access this feature by toggling it on the taskbar at the bottom of your screen. This meeting is being recorded, and we will make the recording available to you on our website in the next few days. And finally, if you lose your connection, please use the same Zoom link to reconnect. We would now like to begin by thanking our sponsors. Our premier sponsor is MEMIC. Our program sponsor is Littler Mendelson. Our supporting sponsor is Cross Insurance. And our 2025 webinar series sponsors are AARP, Bangor Savings Bank, Kennebec Savings Bank, MEMIC, Merrill's Investigations and Security, Northeast Delta Dental, and Summit Natural Gas of Maine. It is now my pleasure to introduce Jacob LaChance, who is a government relations specialist with the Maine State Chamber of Commerce. Jacob will be teeing up conversation today. Good morning, Jake.
Morning, Richard. Thank you so much for that introduction, and thank you again to our sponsors. Um, Another year, another HR update here for the chamber, and we're always super lucky to have now for I believe the second year in a row a team from Littler Mendelson that'll be briefing us on what employers need to know in the workplace when it comes to drug implications, testing, how to best conduct sexual harassment investigations, how to create effective policies for managing gambling in the workplace, and how to navigate accommodation requests by employees affected by gambling or drug and alcohol addictions. It's one of those things that's definitely prevalent in the workplace and kind of swept under the rug at times. So knowing how to deal with those things from an employer's perspective is super important. So I want to welcome the team from Littler Mendelson, Melinda Caterine, Ellen Donovan McCann, and Steve Silver. We're super fortunate to have their expertise with us here this morning. With that, Steve, I will turn it over to you. Thanks for being here.
All right, good morning. So we're gonna cover these four broad topics. First, talk about drug testing, in particular marijuana, which it seems like old news now in Maine, but the recreational program is not that old, but it's pretty prevalent. Gambling in the workplace. I'm willing to bet that most of you have gambled in the workplace and may not know it. So we'll talk about some policies with that, and then workplace accommodations, particularly when we're talking about addiction-related issues. And then lastly, spotting and preventing sexual harassment and some tips if you have to conduct internal investigations. First, just a brief bit about Littler. All we do is labor and employment. We like to say we're the largest boutique law firm in doing labor and employment. You can see some of the practices we have, industries we serve, and quite frankly, we're local everywhere that you are or have employees. As you can see on the map, we've got New England covered and folks in just about every state. Also, all over the world. So for you whether you have presence globally or just a remote employee, there may be issues that come up and we can certainly help you with that. But here locally in Portland, Maine, we have a great team of 7 lawyers and who focus exclusively on labor and employment issues. Now, one thing about Littler, if you take away anything, is I encourage you to go to littler.com/subscribe. You can pick based on industry, your topic, various sort of jurisdictions, and get free analysis, publications, reports from our attorneys. It's an incredible resource. One that's going on right now is the Trump administration tracker. So every executive order that's either issued, rescinded, it's on there with some analysis on how it would affect your operations and your employees. So I encourage you to do that today. And with that, I will turn it over to Mindy Caterine.
Good morning. Thank you for joining us today. I'm talking about marijuana in the workplace. Medical or recreational marijuana. Doesn't matter. It really does, and we'll talk about that. To test or not to test, that's a great question. I have a personal opinion, and we'll talk about that too. Is my employee impaired? That can be very difficult to determine. And can I discipline my impaired employees? If an employee shows up to work under the influence of drugs or alcohol, absolutely, you can discipline them for that. So we'll get into that as well. Recreational cannabis sales total 244 million in 2024. This is in Maine. More than 110,000 medical marijuana patient certifications in 2024, and medical marijuana market brought in 234 million in 2024, and that's a lot of tax dollars. But is there a downside to that for Mainers? The National Institute on Drug Abuse found that 55% more industrial accidents, 85% more injuries, and 75% greater absenteeism among employees compared to those who tested negative. The National Highway Traffic Safety Administration indicates that 30% of drivers involved in fatal crashes tested positive for at least one drug. Among them was marijuana, which was the most prevalent. So there is a definite downside to marijuana in the workplace, and these statistics are from 2020. So these numbers are probably higher today than they were back then. So 39 states, 3 territories, and the District of Columbia allow the medical use of cannabis products as of February 1, 2025. 24 states, 3 territories, and the District of Columbia allow or regulate cannabis for recreational use as of the same date. So it's expanding throughout the United States. Maine's Medical Use Act prohibits employers from penalizing or refusing to hire employees solely because of their use of medical marijuana. But this doesn't mean that employers have to tolerate impaired employees at work or in the course of their duties. The Medical Use Act does not require employers to accommodate the ingestion of marijuana in the workplace, and employers are not required to accommodate employees working while under the influence of marijuana. So there are limits to an individual's ability to use medical or recreational marijuana. And while the statute pertaining to medical marijuana prohibits employers from discriminating against employees or applicants based on their use of marijuana, the adult use statute is focused on the employer's ability to maintain policies prohibiting the use and consumption of marijuana at work, and also to discipline employees who are impaired at work or who bring marijuana into the workplace. When the legislation initially passed, I'm sure some of you recall this, it included a provision preventing employers from taking adverse action against employees based on the employee's off-duty use of marijuana. That provision was subsequently vetoed, and it's not present in the existing law. So employers can and should discipline impaired employees in accordance with workplace policies and procedures. But determining impairment can be a difficult task. And I'm sure most of you have heard that urine tests may detect marijuana use that occurred, up to 90 days before the test was taken. So how accurate is that really? We don't have a scientifically accepted equivalent to the breathalyzers used by law enforcement to test for alcohol intoxication, and we currently have no scientifically valid tests that measure marijuana impairment at the time in question. So there's a reliability issue. Also, impairment is not correlated with dosage. Testing for levels of cannabinoids does not effectively determine how impaired a person is. So just because somebody has marijuana in their system doesn't mean that they're impaired while they're at work or while they're doing their work duties. So you have a situation where employees come to you and tell you that you have a coworker who's high and he's consumed edible marijuana immediately before reporting to work. What do you do about that? Can you test this employee? Perhaps. Is this a federally regulated employee subject to a DOT policy that not only authorizes but requires you to test under these circumstances? If so, you're obviously allowed to test. But if this is not a federally regulated employee who is subject to a DOT policy or some other federally mandated policy, can you test the allegedly impaired employee based on the coworker's reports? Again, the answer to that is maybe. This depends on whether or not you have a drug policy in place that's been approved by the Maine Department of Labor, and if you have a policy that allows for reasonable suspicion testing, you might be able to test that employee. Under the Maine statute, a supervisor, licensed medical professional, or one of the employer's security personnel must make the probable cause determination. And the employee is entitled to have the written probable cause determination provided to them. So then the question is, should you test the employee? Again, that's a maybe. Is the employee a medical marijuana user? If so, a positive test result alone won't allow you to discipline that individual. And if he's not a medical marijuana user and he tests positive for marijuana, can you terminate his employment? Well, probably not immediately. Under the Maine statute, somebody who tests positive as a result of a substance abuse test is entitled to up to 6 months of rehabilitation, and in most instances, the employer is required to pay for at least a portion of that. Another problem with positive drug tests is that it doesn't prove your employee was under the influence of marijuana at work. The marijuana could have been used, weeks before, but the individual still tests positive. So it doesn't really get you the information that you want or need. But he's high. His coworkers described someone who sounds undoubtedly impaired and high as a kite. And you saw him. You believe the same. He looked just like a character from The Big Lebowski, or maybe Dazed and Confused. We have to thank Steve for those references. And he bragged to his coworkers about the tasty gummies he enjoyed after breakfast on the way into the office. So what do you do about this? That's a great question. If you want to terminate for this kind of incident, your focus should be on some very practical things, making sure that you document all of your observations in detail, describing exactly what was used to demonstrate the impairment. And the Maine DOL has an observed behavior checklist, and the focus is on, appearance, behavior and speech, awareness, and motor skills. And I'd suggest that you all get a copy of that and use it. And it's critical that employers work to train their supervisors and HR professionals to recognize the signs of impairment so that they know what they are and understand how to document it. And they should be trained to use the observed behavior checklist from the Maine Department of Labor. So while your gummy consuming employee was entitled to enjoy his gummies at home, the law does not protect him if he shows up to work and is impaired. However, instead of sending the employee for a drug test, you may be better off documenting the observed behavior and terminating on that basis, because there are several requirements under the Maine substance abuse testing statute that prohibit you from taking immediate action against the employee. So in that instance, you may be better off actually not testing. Okay, some best practices. Employers should maintain a clear and explicit policy prohibiting marijuana use, possession, and impairment at work and outside work when performing work-related duties, driving a vehicle for work or at a firm function that's outside of work. And make sure that the policy unambiguously states the violators will be disciplined up to and including termination of employment. And you also need to make sure that you consistently enforce that policy. Aside from best practices related to identifying impairment and discipline, we also need to consider best practices when it comes to the ADA and the Maine Human Rights Act and medical marijuana. Human resources representatives need to be trained on the reasonable accommodation process and the questions to ask medical marijuana users when engaged in the reasonable accommodation interactive process. Questions may include things such as whether the medical marijuana use results in the employee's impairment during work hours, whether the marijuana treatment schedule and dosage levels will result in the individual reporting to the workplace in an impaired state, whether the employee must consume medical marijuana during off-duty work hours, such as a mid-shift break, whether the employee's jobs involve safety-sensitive duties and responsibilities, whether the employee's underlying medical condition is temporary or permanent in nature, and what types of accommodations can be provided to an individual to ensure he or she will not report under the influence of a substance abuse, of medical marijuana or recreational marijuana. Possible accommodations for medical marijuana user may include transfer to a different job position where potential impairment doesn't implicate safety issues, a modification to the work schedule, temporary leave, modified job duties and responsibilities. So your HR people need to be educated on these issues and need to make sure that somebody who reports that they are a medical marijuana user and may need an accommodation that you engage in the interactive process. Drug testing. So in Maine, if you do engage in drug testing, you must make sure you have a drug testing policy in place that's been approved by the Maine Department of Labor. And employers must involve employees in the development of the substance abuse testing policy. And once the policy is approved by the Maine Department of Labor, the employees must be provided with a copy of the approved policy at least 30 days before the policy takes effect. In addition, if the employer has more than 20 full-time employees, it must have an EAP program that's been approved by the Department of Health and Human Services. So there are model policies on the Department of Labor's website that you can follow. It looks very complicated, but if you use one of the CAN policies that's already been approved, it really expedites the process, and it's not really quite as intimidating as it looks. EAP programs. They can be a very low cost, effective tool. They can help to reduce absenteeism. They can improve productivity. They can decrease workplace incidents. And if you have a drug testing policy and you have more than 20 employees, then you are required to have an EAP program in place that's been certified by the Department of Health and Human Services. Safety sensitive issues. If we're not dealing with a safety sensitive job, then and if somebody is using medical marijuana, then they oh, sorry, let me Let me rephrase that. Okay, if it's a safety sensitive position and there is no medical marijuana being used, then sorry, I lost my thought there. Okay, so if you have a safety sensitive position that you're dealing with and the employee is a medical marijuana user, then the discussion should include what are the job duties. So you need to make sure you have a job description that is up to date and accurate. You need to understand what the safety implications of the employee's position are, the quantity and potency of the employee's marijuana use, the time of day that the employee is using the medical marijuana and how long the intoxication lasts, whether the employee's usage is short-term and temporary, or whether it's long-term and chronic. And it's also important to understand that whether or not an employee presents a safety risk to himself or others, it cannot be speculative and remote. It must be based on objective medical evidence. So you don't want to make assumptions about an employee's limitations, and you don't want to make determinations without obtaining some objective medical evidence to support your decision. If you're going to exclude somebody from a safety sensitive position based on their use of medical marijuana. If an employee has any employees who are subject to a federally mandated drug and alcohol testing program working in Maine, that employer may expand the federal testing pool to cover all employees and forego the use of a state-approved plan. However, it can be expensive. It can be more expensive than following a Maine policy. And DOT, and for example, the DOT regulations require pre-employment testing, random testing, probable cause testing, return to work testing, follow-up testing, and post-accident testing for employees who are subject to these DOT testing policies. And for follow-up testing, it's required that it be 6 times per year after a positive test. So it can be time-consuming and expensive. And unfortunately, the federal program doesn't allow any latitude regarding outcomes that might be lawful under state law. For example, an employer would have to treat an employee who tests positive for marijuana as having violated the substance abuse policy and subject them to disciplinary action, even if that employee obtained and used the marijuana lawfully. And we've seen plenty of opinions out there from the court stating that federal law does not preempt state drug testing laws. So it can be complicated, and it's not without risks. So if you're going to go that route, you want to make sure that you engage the assistance of employment counsel to walk you through that. The Maine Department of Labor has some great guidance on marijuana in the workplace. If you go to their website, they can show you where the approved drug testing labs are, their model policies that you can use, either applicant testing, employee testing, or a combination of the two. It also walks you through what substances you can test for and the cutoff levels. And also a great sample drug-free workplace policy. And I would also encourage you to go to the website and obtain the observed behavior checklist. It can be invaluable for you in determining whether or not you reasonably believe an employee to be under the influence of drugs or alcohol at work.
All right. Thanks, Mindy. And if you don't all want to run out and grab a joint right now, we can talk about gambling in the workplace. I love talking about this. It sort of combines my two worlds as an employment lawyer, and I'm currently chair of the Maine Gambling Control Board. So if you have questions about anything related to gambling, I'm happy to answer them. Just a brief bit of sort of how we're organized in Maine. In essentially 15 years, Maine has gone from basically no legalized gambling to having 2 casinos, charitable gaming, fantasy sports, advanced deposit wagering, which is online horse betting, and most recently sports betting, both mobile on apps and in retail. The Gambling Control Unit is a part of the Department of Public Safety, and the unit oversees charitable, fantasy, and sports betting. The board, this is where there's some confusion. The board, which is a 5-member board appointed by the governor, confirmed by the Senate, only oversees the casinos and ADW. So there's sort of a division of labor between the board and the unit, and that can get complicated, certainly for our friends in Augusta when they're passing bills. So the website has tons of great resources. If you're planning a raffle or a sweepstakes, there's registration forms. You can get all of the information about revenue and any sort of legislation that's pending too. So great resource there. All right. I get this question at least once a week from our clients. Hey, we have a plan. We want to do a giveaway or a raffle or a contest. Is it gambling? And every state is a little different. But at its core, there's 3 elements. All right. Consideration, chance, and prize. Prize, super easy. Are you winning something of value? Chance, is it random? Consideration is the tricky part. Are folks giving up something of value for the chance of winning that prize? And that's where factual analysis really matters and looking at the state-specific language. So here in Maine, gambling or game of chance means a game, contest, scheme, or device in which someone risks something of value for the opportunity to win something of value. That first part is broader than some states because something of value can be almost anything. And in fact, there are court opinions saying that just providing an email address, right, to sign up for the chance to win something, that could be something of value, right, depending upon who the recipient of that email is and what they're planning to do with it. So again, depending upon what you're asking your employees or members of the public to do to win that prize, you could be triggering that. Chance, meaning it's outside the control of the contestant, and cannot be eliminated through skill. This is where Maine differs from some states. Some states use a predominant factor test where they just look at, is chance the bigger element or is skill? In Maine, it's can chance be eliminated through skill? And so you look at sort of games we all know, right? Roulette, there's no chance your skill, and I guess unless you're psychic, is going to change the outcome. And then you sort of go along the spectrum. There's some skill in blackjack. There's certainly skill in poker. That's how we have poker pros. Same with sports betting. But does it eliminate chance? And then free throw shooting contests. If you're a professional NBA player, really good at that, you probably can eliminate chance, but maybe not all of it. So there's somewhat of a spectrum there. And most recently here in Maine, we legalized sports betting. This all came about from a 2018 Supreme Court case. Some of you may be familiar with. And there was a federal prohibition on sports betting. One thing, even to this day, I see wrong in newspapers and the talking heads on TV is they say, well, the Supreme Court legalized sports betting. That is not what the Supreme Court did. The Supreme Court struck down the federal prohibition and they left it up to the states to decide. So in certain jurisdictions, sports betting is very much illegal. And even in states like Maine, where it is legal, there's plenty of operators, especially offshore operators, who are soliciting your employees to gamble. And we'll talk about some of the risks with that. But interesting, just factual history. The sports leagues, they're the ones who sued to prevent sports betting from being legalized. The federal government had nothing to do with it. Um, and of course, every one of these leagues is now partnering and profiting with the sports book. So uh, things change fast. And here's where we are, just in that time, right? This was June 2018. So less than 7 years, we now have 40 states that have legalized sports betting. Here in Maine, we launched in November of 2023. So, just over a year and a half ago, we have two mobile operators and one retail operator. Now, the mobile piece, that's where 90% of the wagers are placed. That means anyone can bet 24/7 on a phone, tablet, computer, anytime, anywhere. That means it's probably happening with your employees right now, right? We are in NHL and NBA playoff season. There is a lot to bet on. You've probably got some afternoon baseball games, right? Soccer games going on in Europe. So what do you do about it? Uh, you know, I always use this as an opportunity to look at your internet and mobile device use policies. These policies have probably been copy and pasted from old handbooks for years, and no one's really thought about what's it targeting. But something to consider. Also, just educating employees. We'll talk about, depending upon the industry you're in, that can really matter. Um, how do you handle gambling addiction? And Ellen's going to talk a bit about that too, but it's not uh, alone by itself a protected disability. So what do we do about that? And then just prepare, right? Folks are going to bet, whether it is using a sportsbook app or a bracket, Super Bowl square, something like that. It's going to happen. So we want to be prepared for that. Now, uh, question you can all examine before I go to the next slide. Do you already have gambling in your office? And I'm willing to bet you do, because we're not talking about just casino games or one of the sports betting apps. It's these things, right? We've all seen the March Madness bracket, Super Bowl squares, internal contests, and fantasy sports, which maybe fantasy sports has gone down a bit in recent history, but I think a lot of offices still will have, a season-long league and conduct drafts. The vast majority of folks I talk to say, well, this is not gambling. If it's for money or something else of value, it absolutely is, right? It's consideration for the chance at a prize. And arguably your skill cannot take away that chance. Certainly a question on fantasy sports, but for these other things, probably not. So you want to assess, and there's a lot of pros to allowing this. You know, do we permit this, and do we want to permit it and encourage it? And there's reasons to do that, right? It certainly builds camaraderie. It's a great distraction from work. It gets people together, especially as folks are working in hybrid or remote roles. It can be a lot of fun. I remember, sort of pre-COVID, when we were all in offices, it's fun to sort of huddle around the TV in March and watch the end of a basketball game together. So, you may want to do that, and that's great. But also remember there's some cons. The loss of productivity is enormous. We just came out of March. Maybe you all experienced some of this. These numbers are pretty staggering. $20 billion lost in the US. And the average fan spends almost 2.5 hours per day during the tournament, checking scores, updating brackets, and live streaming, right? That's the other thing that comes with mobile betting. We all now can stream the games on phones or on computers. So you don't actually have to go huddle in the lunchroom anymore. You can just watch it at your desk, and hopefully not while driving a company vehicle, but that could happen too. And then I always like seeing what number it is, because they update it every year in terms of how many people plan to call out sick after the Super Bowl. So this year we were almost at 23 million. And how accurate that is, I don't know, but It's certainly in the millions. So I like to see employers flip it, say, hey, the day after the Super Bowl, we're gonna have, free lunch and wear your favorite team's jersey, encourage people to come in. Um, but you want to, certainly set expectations and apply your policies uniformly. The other thing, not as frequent, but it happens, are sort of the typical workplace conflict, right? With harassment or even discrimination. Tempers can flare when money is at stake. And you want to be mindful of that. And also, uh, are people being excluded? Right. Okay. There's a weekly office poker game. Um, is it being held in the office? I worked at a place that it was, and were certain folks being excluded. That can cause trouble. Fights about the fantasy league draft and who gets first pick. I mean, there's things to look out for. Um, Another place I worked at, not Littler, um, we would do brackets, March Madness brackets, but it was attorneys only. The staff weren't allowed to participate. That was a weird and sort of uncomfortable and needless strain and division, in my opinion. Include everybody, particularly if it's free. I mean, why not? Um, uh, and encourage, if you're aware that things are being organized or you as the employer want to sponsor it, try to make it free. You take out that consideration element, and you could fall outside of all the gambling concerns. Give away, some company swag as prizes. Make it a charitable donation in the winner's name. Something fun that doesn't touch on the gambling laws. And be mindful. I love this picture. Not everyone cares about sports, right? All this talk bores some people. It can be annoying, and don't force people to participate if they don't want to. Um, One more con, and this is an extreme case, but I think it teaches a valuable lesson. This is a real case. Um, this individual was running an office survivor pool. It means every week you pick a team, and as long as your team wins, you stay in the pool, and it eliminates on down. It got so big, right? 8,000 entrants, was prosecuted under New Jersey law. Um, and the assets were seized that included the employer's computer and servers. Um, that's an extreme case, but it shows the risk. If you have knowledge, and the factual background here is that the employer did have knowledge this was going on and didn't do anything to stop it, and may have actually encouraged it to some extent. So be mindful that that can happen. And then just to touch upon, uh, you know, the sort of big problem, right, is addiction is real and it's growing. Um, you know, Certainly at the Maine Gambling Control Board, we've devoted a lot more resources to this. We've seen a gigantic spike in calls to the state helpline. We've launched, remote counseling for folks who have problem gambling. It's just unavoidable at this point. You can't watch a game without being inundated with gambling related things. So those triggers are something to be mindful of, right? The brackets and squares can be a trigger for folks. And that's where we want to avoid, forcing people to participate. There may be reasons, right, that they don't want to disclose and they don't want to. So it's a good training opportunity for HR folks, just like you would look at alcohol or drugs. Um, you know, there's signs folks may be having gambling issues, and there's real risk to employers. Pulled out some examples. Um, you know, I like to say it's usually good employees. It leads to bad choices because they're driven by this, and you can see a lot of fraud. Um, this study, which is a little outdated now, but I would actually think the number is probably higher. That gambling was a significant factor in a quarter of business fraud cases. Um, Folks need money and they come up with schemes to defraud an employer for it. Um, So this is prevalent. It's real. Honestly, I don't think we're ready to deal with what's coming in terms of having full online casinos. 7 states have it now. Maine is currently considering it. There's a bill in the legislature for it. And that would mean not just sports betting in your employees' pockets, but full casinos, slot machines, roulette, blackjack, everything. Now, putting all that aside, you want to run, a contest or a sweepstakes, or a raffle, be mindful. Certain states have registration and bonding requirements, like New York and Florida. Um, Maine for raffles, there's a $2,500 threshold in which if your prizes cross that, you got to register. And there's a small fee to pay. There's exceptions for certain nonprofits. I can't tell you how many times I see things being advertised that are certainly not registered and not uh, appropriate, and you'll probably get a letter from the state reminding you of that. So if you've got a plan for raffles or a sweepstakes, you know, consult with counsel. It's a worthy exercise. You don't want to run afoul of these laws. And then one other sort of example of, you know, gambling in the workplace that can go haywire. It's actually a Title VII case. Um, Here, this employee was fired for operating a football pool, but claimed that management was aware of it, and actually tolerated it, but that was the pretext for racial discrimination. Um, and this is a good reminder to develop consistent policies, right? So there cannot be a claim, well, you targeted somebody because of a protected trait if your policy is gambling is not allowed, right? And you apply it uniformly. So that's why you want to go revisit those policies, and make sure your employees are on notice of what is and is not allowed. One thing take away to go revisit is your internet use policy, right? Um, Probably hasn't been looked at in a while. What sites, if any, are you blocking, right? Some at social media, porn, even Gmail for security reasons at times. What about gambling sites? What about both offshore sites, sports gambling news sites? I don't know. You may or may not want to do that, but I think it's worth going to look at that. Um, are your employees on notice, right? Are you monitoring their internet activity? There's all sorts of privacy issues that come along with that. Can they stream videos at work on company devices? Um, uh, what are the expectations? Have you set them? And if not, you may want to. Same with mobile device policies. Um, there's no one size fits all policy, right? This is going to depend on your workforce, your industry. Um, you know, are folks, bringing their own devices? Are you providing them? But some questions to ask about that, as to what do you want to do with those devices, and do you want to limit what your employees are doing, and then have a plan in place for managing risk. Um, Certainly keeping your technology, updated. But do you have a privacy and security team? Like, who responds if there's a breach? If your employees are using these offshore unregulated gambling sites, that could leave you vulnerable. And again, I know this is probably on every slide, but be consistent, right? Make sure folks know what the expectations are. Um, and then lastly, I mentioned it before, sports betting is a ban right for you. Um, it may be. One of my clients is actually a law firm that only does work in athletic space, anti-doping things. They ban all their staff from betting on sports. That makes sense for them, right? Because they're interacting with these athletes and they have knowledge of, things that could influence outcomes. Medical facilities, right? If you have athletes coming, and I know a number of local facilities do for PT or other treatment, maybe you want to consider that. Media outlets, you've got reporters in the locker rooms. Are they gaining information ahead of time? And a number of colleges and universities have tried to do this, really hard to monitor and enforce, but something to consider. So with that, I'll turn it over to Ellen, who's going to talk or tie this together with accommodations, and let me give you control. Hold on.
Thanks, Stephen. And every time I watch Steve present on gambling, I learn something new. But one thing, Steve, I have to learn from you is actually how to gamble, because I've only done sports betting once and I completely messed it up and bet for my team to win by 1,000,000 points when I thought I was betting them to win by a small percentage. So need a little help with that, either that or we should just ban me from gambling altogether, because I'm clearly not good at it. So I'm going to talk a little bit about the laws that govern disability in the workplace. And of course, we'll touch on the themes we've already started talking about. So drug use, alcoholism, gambling in the workplace as well, but really want to kind of make this a little bit more broad to begin with, because I think at least when I talk to HR folks, it could use a refresher on disability in the workplace and what those requirements are and what folks need to do. And so we'll really start with kind of that refresher. So what are the different laws that apply to disability in the workplace? Of course, we're all familiar with the ADA, the Americans with Disabilities Act. That's going to apply across the United States to any employer with 15 or more employees. But then what folks often lose sight of is there are also state disability laws that are occurring in vast majority of states, including states like Maine. And what state law can do is state law can always be more generous than federal law. States can never take away rights federal law promises to employees, but they can always be more generous. So as I go through this, I'll talk to you a little bit about how Maine is often much more generous than federal law. For instance, Maine's definition of what is a disability is much more broad. And the statute acknowledges that right out of the gate, that Maine wants to be more broad than federal law. And so when you're in a state like Maine, or if you have, to Steve's point earlier, you may have remote employees in a variety of states, make sure you look at those state disability laws when you're looking at an employee's request for an accommodation, or if you're looking at behavior that might be motivated by disability, make sure you're taking a look at those state laws, because they can be more generous than federal law. And then finally, what are your own company policies? Companies always have the right to adopt policies that are more generous than both federal and state law. And many companies do, because they want to foster a certain type of environment. And that environment may not just be one that's worried about what is legally actionable behavior, or what is a legally actionable or defined disability. It may be something that goes more broadly than that. So make sure you're taking a look at that as well. And if you do not want your policies to cover individuals who are not necessarily disabled under state or federal law, then be really careful about how you're drafting your policies, so you are not extending protections in the workplace that may go beyond what you're required to do under state or federal law. And so as we're thinking about what is happening here, we want to talk a little bit about, what does the ADA require? I think everybody's pretty familiar with the basic requirement that under the ADA, as employers, we can't discriminate or retaliate against our disabled individuals. But that prohibition, or that mandate, is pretty broad. It really relates to any term and condition of employment. So when you're thinking about discrimination or retaliation, you need to think about all of the different terms and conditions and benefits of employment, not just things that may be really obvious to you. And we'll go through some of those as we go through the presentation. But the other really important requirement of the ADA is that employers have to provide reasonable accommodations to their qualified individuals with disabilities, provided those accommodations do not create an undue hardship. So Maine, for instance, defines a qualified individual with a disability as someone who can perform their job with or without a reasonable accommodation. So you have to be qualified, and qualified really means you have the essential skills, qualifications to do the job, and you can perform that job with or without a reasonable accommodation. So accommodations always have to be kept in mind when we're thinking about who is a qualified individual with a disability. How does the ADA define disability? It's a little bit of a hyper-technical definition, and it really does throw some people off. But basically, it includes any physical or mental impairments that substantially limit an employee in performing one or more major life activities. I know that's a little bit of a legalese type definition, and it's probably a lot for folks to try to decipher. But there is a standard that the employee has to meet in order to determine whether in fact they are disabled. And when we're looking at these impairments, impairments aren't limited to just actual impairments. They include impairments that are someone having a record of being impaired, or when the employer perceives someone or regards someone as being impaired. And so those are things we need to think about as well. So if we think of a couple of examples there, because those are a little bit harder, I think, for folks to grasp. When we talk about having a record of impairment, you could have an applicant who has a record of having cancer. Maybe they're in full remission, but an employer decides not to hire them because they're concerned about increased group medical costs if the cancer comes back. That is disability discrimination by that employer. Or you could have an employer who thinks an employee is disabled, just maybe because of what they've witnessed, or maybe they have some preconceived ideas which might be incorrect, and they make an employment decision based on that perception or that regarded as disabled status. That is also disability discrimination. And I mentioned that state laws can often be more generous than federal law. Maine here is a perfect example. So in Maine, you have some of the same definition as you have under federal law. So we have that physical or mental impairment that substantially limits a major life activity. But we also have in Maine anything that significantly impairs physical or mental health, which is a little broader than federal law, as well as a condition that requires special education, vocational rehabilitation, or related services. So when you're looking at a Maine definition, keep those components in mind, because they don't necessarily align perfectly all of the time with federal law, and they may provide greater protection. Maine also lists some very specific conditions that will be considered to be disabilities, such as major depressive disorder, someone who's had a mastectomy, Parkinson's disease, heart disease, and epilepsy. So those are things you want to be really well aware of, particularly if you have a large percentage of your employees in Maine, so that you're not running afoul of the Maine disability law, even if you're complying with federal law. Major life activities, when we think about how to define a major life activity, these are, again, sometimes really easy for us to understand. Things like caring for myself, walking, sitting, standing, concentrating, things that we all know are major life activities. But they're also covering more subtle things like interacting with others, which can be a huge issue at work, as we know for some individuals. It also can include impact to a major bodily system. So it goes beyond what we might normally think of. And it really is all encompassing when we're thinking about what are those major life activities that have to be substantially limited for someone to be disabled. So getting back to kind of some of the things Steve talked about and Mindy talked about with addictions and gambling, how does everything I just talked to you about apply back to these concepts we're talking about today? Alcohol and drug addiction are treated slightly differently under federal law. So when it comes to alcohol addiction, the EEOC, which is the governing body that regulates the employment discrimination laws in the US, says that an employee who uses alcohol, even if they're currently using alcohol, is not automatically declined protection under the ADA. So if they have a condition that substantially limits a major life activity, they can be covered under the ADA, and that alcoholism can be considered to be a disability. The EEOC also says that an alcoholic is a person with a disability under the ADA and may be entitled to accommodations if they can perform the essential functions of their job with or without an accommodation. Most often accommodations we see maybe leave to attend treatment or to go into rehab. However, what's really important to think about is that even if someone is an alcoholic, an employer does not have to excuse either poor behavior or poor performance at work if it's caused by the use of alcohol. An employer also does not have to waive any type of policy requirements that employees cannot show up at work or cannot attend work functions if they are intoxicated. So those conduct and behavior rules still apply, even if the person is in fact an alcoholic and is using alcohol at work. Maine Human Rights Act, which is the Maine disability statute or contains the Maine disability rules, specifically defines alcoholism as a covered disability as well. So if we move to drug addiction, this is treated just slightly differently than alcoholism. Under drug addiction rules, if someone is addicted to drugs, they're only protected under the ADA if they are not currently using illegal drugs. So anyone who's currently using illegal drugs does not have any ADA protection. They're not entitled to accommodation. They're not protected by the anti-retaliation provisions as well. However, someone who is in treatment, who is no longer using drugs but may have an addiction, can be covered under the ADA and is subject to protection, may be required to provide them with an accommodation. Again, leave to seek treatment is the most common that we see. So we want to make sure we're taking into account these distinctions and we're protecting individuals when we should legally protect them. And going back a little bit to some of the discussion Mindy had before, under federal law, someone who has a drug test that shows an illicit substance in their system qualifies as being a current illegal drug user and is not subject to ADA protection. They may be subject to state protection, and Mindy did a great job running through all of that for us. But that's how it works, of course, under federal law there. Maine law also protects someone who has a history of drug use, of course, provided that they have either successfully completed a supervised drug rehab program and are no longer using drugs, they're currently participating in that program, or even someone who is regarded as having or using or having drugs who actually is covered under Maine law as well and protected from retaliation. So what about gambling? Steve talked to us quite a bit about gambling, and I think Steve mentioned this, but it's worth repeating. The ADA specifically excludes compulsive gambling from the definition of a disability, as does the Maine Human Rights Act. So gambling in and of itself, or gambling addiction, is not protected. However, what we often see, and you can see a couple of really great studies here that Steve pulled together for me to include in my slide, what we often see is that gambling is typically goes hand in hand with another condition that is likely to be covered under the ADA. So often folks who have compulsive gambling issues also may have mental health disorders or other disabilities that may need to be accommodated. So we need to be careful about this comorbidity or coexistence of a gambling disorder with other types of disabilities that may in fact be covered, and we want to make sure we're keeping an eye on it. And you can see the statistics here. These numbers are staggering. 96% of people have these comorbidities in one study, 94 in the other. So it's really something for you to think about rather than a knee-jerk reaction. Oh, I don't have to accommodate gambling addiction. Make sure you understand the full picture of what might be going on with your employee. So I mentioned earlier that one of the real key tenets to ADA is that we have to provide reasonable accommodations to our employees who have disabilities. But what is a reasonable accommodation? What does that mean? It really simply just means changing working conditions, changing policies, making changes to the employee's employment setting so that they can perform the essential functions of their job with or without these reasonable accommodations. But it also has to allow the employee to be able to have access to equal benefits and privileges of employment. So it really is a pretty all-encompassing standard here that we want to make sure we are considering for our employees. How does the court, or how does the EEOC, how is reasonable interpreted? Well, in order for an accommodation to be reasonable, it has to be effective. So it has to be effective at allowing the employee to perform the essential functions of their job. Excuse me, if it's not effective, it's not reasonable. And there's no requirement for an employer to give an employee the exact accommodation they want. The requirement is to give them an effective accommodation, i.e. one that allows them to perform the essential functions of the job. So if there are numerous accommodations you could choose from, you can choose the one that is effective. You do not necessarily have to give your employee the one they want or the one that they think is best. But remember, it has to be effective. And I'm going to repeat the next bullet here several times. You do not have to excuse someone from performing the essential functions of their job as a reasonable accommodation. A reasonable accommodation is one that helps the employee perform those essential functions of their job. You can seek medical information when the disability is not obvious. You do not already have information that documents that disability, and when you're not sure if the employee needs an accommodation. But this is a place that you can get in trouble really quickly when it comes to requesting medical documentation for your employees. So I strongly suggest you work with your counsel when you're thinking about seeking medical documentation, because there are limits on what you can get. There are strict confidentiality rules, and there are different rules depending on whether you're talking about an applicant, someone to whom you've made a conditional job offer, or an existing employee. Yeah, I don't know what's going on here. Okay. Yep. Sorry about that. Okay. All right, so what is not a reasonable accommodation? I already mentioned this, that reasonable accommodation is not excuse of essential functions of the job. It is not misconduct, even if it is caused by a disability. You do not have to excuse violations of company. This is my slides have taken on a life of their own. You also do not have to excuse any violations of company policy, even if caused by a disability. You do not have to excuse violence, threats of violence, or unprofessional behavior, or disrespectful or inappropriate behavior. Okay, so what is an undue hardship? I mentioned that you do not have to give an accommodation if it creates an undue hardship. Undue hardship is one that is either unduly costly, is extensive or disruptive, or it fundamentally alters the nature of the business. In Maine, again, we have examples that are much more generous to the employee than under federal law. Maine gives you a long list of factors you can consider to determine if something is in fact an undue hardship. So you can consider things such as the nature of the cost of the accommodation, the overall financial resources of not just your organization, but the individual facility at which the employee works, the number of employees that work there, the impact to the organization. You can consider the type of operation you have. I know a lot of Maine employers have seasonal businesses where things create an undue hardship. If you're in your busiest season, that might not create an undue hardship at another time of the year. So those are things you can take into account. Are you receiving government funding, or are there grants that can help you pay for this? Or is it going to be something that you as the employer are going to have to foot the bill for? Those are important considerations. Have you documented good faith efforts to explore other accommodations? Have you tried to minimize the cost of accommodations over time? And to what extent are you saving resources by making those accommodations in the long run? Okay, so how do you respond to an accommodation request? What if someone tells you during an interview that they need an accommodation? Applicants are covered under the ADA, so you may have to give them an accommodation to help them participate in the process of going through the interview system, and we want to make sure we're doing that as well. Every request for an accommodation has to be taken seriously. You want to make sure you're looking at them, you're taking them seriously. No magic words need to be said to you. So if an employee says, I have a medical condition and I need some help, that's a request for an accommodation. If you are a manager, you do not want to grant an accommodation without checking with your HR department, because you have to engage in the interactive process or have a dialogue with the employee about what they might need. Even if a request seems ridiculous on its face, you still have to engage in that process. Never express discomfort, displeasure, or any kind of bias if an employee asks for an accommodation. And then when it comes to documentation, keep that documentation focused on limitations, not suppositions, not perceptions, but really those things that you have witnessed that may be impacting someone's ability to do their job. If you suspect that there may be a medical condition impacting performance, what I always like to advise managers is there's a great way you can approach this without regarding someone as being disabled by simply asking, what can I do to help you be effective at your job? You are now inviting the employee to ask for an accommodation if they need it, but you're not regarding anyone as being disabled. So quickly, I won't go through this slide in great detail, but we just wanted to share some of the examples of accommodations that might be reasonable. Again, depending on your work site, depending on finances and the impact to other employees, but leaves of absence are quite often a reasonable accommodation, provided they're effective at allowing the employee to return to work. So I'm going to shift gears now. We talked quite a bit about accommodations and disability. And now we're going to talk about, this is our last topic, I promise, for those of you who are saying, wow, you've all gone over a lot of materials today. We're going to round this out with a conversation about sexual harassment. So we're going to give you some tips on recognizing unlawful harassment, whether it's sexual harassment or harassment based on other criteria, as well as investigative tips. So what is illegal harassment? It is any unwelcome verbal or physical conduct that's based on a protected class. And those protected classes can be pretty broad. And they can be more broad, of course, as we mentioned, under federal law than they can be under state law. So you can see there are protected classes. It's not just about sexual harassment. It can be harassment based on color, religion, national origin, age, pregnancy, gender identity, sexual identity, or expression. Maine has other protected classes, such as everything in Maine is whether it's actual or perceived category. So the person doesn't actually have to have this protected class. If they're perceived as being in the class, that is prohibited discrimination in Maine. Maine also includes any kind of discrimination or harassment on the basis of familial status, or if an employee has previously asserted a workers' comp claim against their employer, if they've previously made a complaint of illegal activity or expressed that they do not want to engage in illegal activity. And really, this conduct has to constitute one of two kinds of harassment, and we'll go through these in more detail. Does it create a hostile work environment, or is it quid pro quo harassment, which are two different kinds of harassment under the law? So we'll talk about each of these kinds of harassment because they are somewhat different, but they're both equally violative of the laws. So what is quid pro quo harassment? Many of you have probably heard this phrase before. Quid pro quo simply means this for that. It's a Latin phrase. And basically what this comes down to is employment benefits are either given or taken away based on whether an employee acquiesces to a demand for sexual favors or conduct of a sexual nature. You can see some examples here on the slide, but a really kind of obvious, kind of hits you over the head example is manager says to a subordinate, if you go out with me, I will give you a promotion. If you don't, I will demote you. Typically, in these days, we don't see such blatant examples anymore, but it can be more subtle. So manager asks a subordinate out, the subordinate says no, the subordinate gets demoted later. It's not expressly stated that that's what's happening, but that's probably what's happening. This is often a really good reason why employers have nepotism policies and have policies that prevent subordinates and supervisors from dating, because quid pro quo harassment is really based on that unequal distribution of power between managers and their subordinates. And it is often hard to tell, if you're a manager, whether your subordinate agreed to date you because they want to date you or because they're fearful that they may be the victim of quid pro quo harassment. Hostile work environment is much more subtle. And really what happens in hostile work environment is there's pervasive inconsistent, unwanted behavior of a sexual nature that rises to the level that's so severe that it changes the employee's work environment. The conduct has to be unwelcome, but when we're thinking about unwelcome conduct, we're not thinking about how the person who made the comment intended it to be received. We have to look at how the person who heard it or who it was directed at or overheard it took it. So really, this is in the eyes of the beholder, whether it's unwelcome or not. Unwelcome is very hard to judge. So again, I'll share another one of my favorite rules of thumb here. I often tell managers when I'm doing training, if you're in work and you're talking to your coworkers and you find the need to start a sentence with some kind of qualifier such as, I'm not racist, I'm not sexist, I'm not homophobic, but don't finish the sentence because simply by virtue of the fact that you felt the need to qualify what you were going to say probably means what you are going to say is not appropriate in the workplace. So another good rule of thumb on when you're having these conversations at work. Harassing conduct really can take many different forms. It can be physical, so touching, excessive hugging, things like that. It can be verbal, making comments, making slurs, using derogatory names for folks. It can also be nonverbal or visual. So leering at someone, rolling your eyes, expressions, those can all be harassing conducts. And what we would like to say to folks, and Mindy really is a litigator here. I don't litigate anymore, but I'm sure Mindy's had this happen oftentimes. When you're litigating a harassment case, everything that's happened becomes part of that case. Every comment, every joke, every slur, everything becomes part of what is discoverable and discussed in that case. And so this wall of harassing conduct can be put together brick by brick through that litigation. And so maybe one isolated comment, the manager or the person didn't think much about it, but everything is going to be asked about and is going to be looked at to see what really happened, and can create a pattern that can be concerning, or at least that can influence a decision maker that there really was a hostile environment going on, even if that wasn't what was intended. Some more specific examples here of those types of conduct. Again, I won't run through all of this, but you can see it's a fairly significant list of conduct. When you're drafting your policies, you want to keep your policies broad enough so that you're not boxing yourself into just a limited number of examples, but it's always good to include some examples in your policy of what you consider to be harassing conduct, but always saying that the list is illustrative and is not exclusive. So clearing up some misconceptions. We hear these all the time from employees when we're talking to them about their behavior at work, what are some of the things we hear over and over again? The first misconception, do the offender and the offended have to be of the opposite sex or other protected category? And the answer is absolutely no. And the behavior doesn't even necessarily have to be sexually motivated, but it has to be based on sex. So we've seen cases where, for instance, we've seen heterosexual female employees that have found liable for harassing other heterosexual female employees because they target them simply because they're women. Name calling, taunting, criticism for either being too girly or not female enough. That can be sexual harassment, even though it's not based on any sexual desire or sexually motivated behavior. Harassment can be based on more than one protected category. We see this now with intersectionality. The more protected category someone is in, oftentimes the more likely it is that they may be subject to harassment just in general, but as well as at work. Offenders can be supervisors, executives, co-workers. They can be non-employees. So be careful about vendors and visitors and making sure that they are not engaging in harassing behavior towards your employees, because you will be liable for that if you don't do anything to stop that behavior. And then finally, does the person who is offended have to be the target of the conduct? They absolutely do not need to be the target of the conduct. So bystanders can successfully bring harassment cases if they are overhearing conversations that are offensive to them, even if they're not directed to them. The lines here can get really blurry, particularly what is work-related behavior, what is a work-related event, what happens to activities that occur off-site, before work, after work, things like that. Does the company have to pay, if it's a happy hour, for it to be a company-sponsored event? Again, a good rule of thumb here is if you're a supervisor or manager, assume that you are always working if you are in the presence of people that work for your company. Because the rules here are really broad and the company can be responsible for a lot of this activity. So you want to be especially careful and especially on your guard here. That went backwards. These things are very tiny on my screen. Okay, so social media, technology. I think this is obvious to all of us now, but same rules apply to the use of social media as they apply to our behavior in the office or over, when we're outside of the office in the evening. But the difference with social media, as we all know, is once that record's created, it's there forever. Even those of you who maybe love to use Snapchat and think it goes away, I've learned from my children that you can save Snapchats now and you can screenshot a Snapchat. So nothing ever officially goes away. Be careful when you're doing anything over social media. You may feel as if it's a more relaxed environment, but it still can be used against you when we're talking about harassment. So some of the key learning points we've already talked about, particularly watch out for these casual, kind of less formal interactions. Things like lunch breaks, the outside happy hours, anything where people feel more relaxed and more comfortable. Jokes they may cross the line, they may go too far. People may touch each other more outside the office than folks might be comfortable with. And so watching out for things like this, making sure that banter doesn't go too far, and exercising caution to see how other people in the workplace might be impacted by these comments. And remember to always apply your own policy and comply with it. And what a lot of employers want to think about is, what type of environment do I want here? So if you investigate a comment about harassment, maybe it's just one isolated comment that might not rise to the level of being legally actionable, but is it conduct you want to condone in your workplace? Do you want to have Mindy defend a lawsuit for you someday where an employee used a really racially derogatory comment and only used it once, but you look the other way and let it go? That's not a great place to be. Even if at the end of the day, you may win that case, it's just not a place you want to be. So think about things like that as well. make sure you're thinking about the impact on third parties of things that go on. Again, bystanders are bringing claims here. Who's overhearing conversations or jokes, even between really good friends who are coworkers? And those are things you want to make sure you're thinking about in a preventative manner. How do you figure out what to do in the workplace? How do you train your folks to think about this? A good rule of thumb here, as well as what's the golden rule, right? Would I want someone to make a comment like this about me? Would I want someone to make a comment like this about my child or my parent or my grandparent? Would I want my child or grandparent or my mother to overhear the conversation I just had or to hear what I just said in the workplace? And I think most importantly is, would I want to repeat this in a deposition or at a trial in front of a jury? Those are all good rules of thumb when you're thinking about how to behave at work. And so finally, let's talk a little bit about investigations. What are some best tips for investigations? If you are a supervisor or manager, there is no such thing as a privileged conversation or disclosure that someone's been the victim of harassment. You have a legal obligation to inform your company that you have that information. Why? Because when you are on notice, your company is on notice that this behavior is happening, and the company needs to take a prompt and thorough investigation. They need to start that virtually immediately. During the investigation, information should be kept confidential, shared only with those who have a need to know. Employees can be required to cooperate in the investigation and can also be asked to keep information confidential. You want to make sure you're maintaining and documenting the investigative records. I strongly recommend that you have your investigations be done subject to the advice and direction of your legal team or outside lawyers, so that you can maintain privilege with regard to the investigation. You need to make sure that even after the investigation's over or during the investigation, there is no retaliation against anyone involved in the investigation. And then when the investigation is over, you want to wrap it up by getting back to the complainant, particularly sharing with them the findings, but being careful to have a nice balance between letting them know you took it seriously and took remedial action, but not violating the confidentiality and privacy rights of the accused or others that might have been involved in the investigation. From some more practical nuts and bolts tips here, you should always have a witness present when you're conducting interviews. You want to either ask to record the conversation or take detailed notes. You want to make sure that in your mind, assume the employee is recording you, even if your company policy prohibits that. Save your notes immediately. Document your decision-making process, because you could be challenged on this years later. And then provide really clear instructions on what your expectations are about confidentiality as well as retaliation, to make sure you're covering your bases on both of those.
Ellen, let me jump in.
Yeah.
As one of the litigators who sees this all the time, ask yourself, when you're taking these notes, will somebody, if I'm not still here, be able to decipher what these notes are 2 years down the road? Or would you, right, yourself?
Right.
So whether you're writing them down, typing them, it's great to do it at the moment, right? Or immediately after. Don't say, oh, all right, I'll look at this at the end of the week and, go from memory.
Yeah, great advice. That's why I'm always glad we have our litigators on the call to give us those great practical tips. And then finally, just retaliation. We've talked about it a lot, but be careful to avoid retaliation. And that includes punishing someone who opposes unlawful practices, someone who rejects unlawful advances, participates in the interview, or brings any complaints forward. You want to make sure you're thinking about that as well. And then finally, we've talked about this a little bit, but harassment is obviously not the kind of work environment you want, but it's also, from a practical perspective, it can be expensive and time consuming. So you've got productivity impacts, morale impacts, turnover, and then think about the time drain of having to be deposed, having to go to court, having to be involved in that, the potential media exposure that can come from cases like this. It's an expensive proposition, and your better bet is to avoid getting yourself into these situations versus having to defend them later. But if you're in them to defend later, you've got great folks like Mindy and Steve to help you with that. So I think we've got about 5 minutes for questions. So I'm going to stop talking now.
Yeah, thank you so much, Ellen, Steve, Mindy. Ton of information, a lot of stuff that I don't think really employers think about on the day to day until they're in it, and they have to deal with it, like a lot of the different types of labor violations or situations out there. So, thank you so much for taking the time to kind of shed some light on these issues and how they can be navigated. We will use the chat for any questions that pop up. We'll give a little bit of time here for folks to type if necessary. But definitely want to again take this time to thank you three for taking times out of your busy day, and a thank you to the sponsors for making this webinar happen. Any and all questions from the group before we let folks get on with their Thursday? I did see one hand briefly pop up from Virginia. I don't know, as well as Atoka. If you want to throw the questions in the chat, I think that's going to be the best way to navigate this. Oh, I think they're all set with questions. If if that is the case, again, thank you, you three. I don't want to get too in depth with NBA playoff time, NHL playoff time, with all the gambling potentials out there. But if you do so wisely and do so safely. I think that's the overwhelming thing we can take away. So with that, I will say thank you all. If there are any questions, please feel free to reach out to me. More than happy to forward those questions on to Mindy, Ellen, or Steve, and I can get those back to you. So thanks all. Have a good rest of your day.
Thank you.